But if you could talk about why you and not your opponents are better suited for this job.
And since on video, I'd introduce yourself too.
Sure.
You started with me? Great. My name is Jose Garza, and I'm running to be the district attorney because I think our criminal justice system right here in Travis County is broken. Every single day here in Travis County, in the most progressive county in the state, over 70% of people sitting in our jail have not been convicted of a crime. The overwhelming majority of them are sitting in our jail because they can't afford to pay bail. Here in the most progressive county in the state, between 7 and 9% of our population is black, but over 25% of the population of our jail is black. Here in the blueberry in the middle of the tomato soup, our district attorney's office has lost the trust of survivors of sexual assault. And that makes us less safe. I started my career on the border as a public defender, both at the state and the federal level. And in those jobs, I saw every single day the way that our criminal justice system weighs most heavily on working class people and on people of color. I also served in the Obama administration, and it has been the privilege of my career to run Workers' Defense Project here in town. And what those experiences taught me is the power that regular people have to change their community, to change their county, and most certainly to change their criminal justice system. All over the country, people are, communities are grappling with their district attorney, with their criminal justice system as a whole, about the impact of 40 years, 60 years of policy that have led to a mass incarceration crisis across our country and in our state. All over the country, people are grappling with their criminal justice system to solve the sexual assault crisis that is rampant throughout our country. And all over the country, communities with their district attorney's office are putting forward bold solutions to reverse decades of bad policies that have destroyed families, destroyed communities, and made our communities less safe. When I moved back to Travis County, after spending some time on the border and in Washington, D.C., I was convinced that I would come back to a community, to a county that was leading in this effort. But what I have found is that that is not the case. That so many of the reforms that are underway across the country and across the state aren't happening right here in our community. As I said, I have experience in our criminal justice system trying cases in state and federal court to jury trial in both. And I have experience working in our communities with the people who this system most impacts every single day. I am the only candidate who has not spent my entire career advancing this broken system. And it is going to take a completely different perspective. And as I said, bold reforms to create a criminal justice system and a district attorney's office that reflects the values of our community. And so I think there are a couple of things that we are prepared to do right off the bat to end our cash bail system here in Travis County so that we have a system that makes sure that our community stays safe, but also ensures that we are not locking people up simply because they can't afford to get out. It is time to end the prosecution of low-level drugs here in Travis County because prosecuting those offenses makes our community less safe and because they are one of the largest drivers of racial disparities in our criminal justice system. And it is time to sit back down with advocates for survivors of sexual assault to come together for real solutions that will make our community safe. I have the experience, the management experience, the legal experience, and most importantly, the experience empowering impacted communities to make the change that they know they need in their own lives. And I have just been deeply grateful for the opportunity to talk to voters across this county. And I have just been excited about the momentum that our movement is building here. And I personally can't wait for Election Day, and am excited about the change we're going to make here in Travis County.
I'm Margaret Moore, and I am the Travis County District Attorney. I was elected 4 years ago and have been serving since January of 2017. I am running again because there's still work to be done. To answer your specific question about why me instead of my opponents, I would begin with this. I'm the only person with any prosecutorial experience in this race. I have been an assistant district attorney. I was the elected county attorney. I tried cases to juries of all kinds of felonies and even some misdemeanors as county attorney. I also am the only candidate in this race who has experience as an elected official, as an appointed official. I have served this community as a juvenile public defender, as assistant under Ronnie Earl, as the elected county attorney, as a person appointed to the Commissioner's Court twice, which gave me a huge insight into county government and specifically budget setting, which is one of the most crucial areas that an administrator in government needs to know. And ancillary to that, I've also been an assistant attorney general who handled very complex civil litigation, and I also served on my emergency services district board, setting a tax rate for that. So I feel like I'm a very well-rounded person to come into an office that has about 240 people and a budget of over $27 million now. When you would want to look at reform, I would say this. I've been a reform person in Travis County, and in particular in the criminal justice system, since I got into it. And as county attorney, started diversion in this county for cases, shoplifting, hot checks, so that people were not prosecuted for those misdemeanors. We started that. I've come into this system knowing that reform is not something you flip a switch and accomplish. Reform is a process that's ongoing every day. Every day, every week when my executive committee meets, we're engaging in reform because we are looking at how are we using our resources? What are the biggest needs of this county? What makes us safer? What's the right thing to do? This is what we do. And I have assembled an office for this community to be proud of. We now have a presence across the state that I thought was achievable by the Travis County DA. And I'm very proud to say that my colleagues across the state have said, well done. We're so proud that Travis County is now a shining example of what a DA's office should be. We've done things that are absolutely innovative compared to any DA's office. I point to my Civil Rights Division. The way we are now handling officer-involved use of force cases is absolutely unique to this county. It was devised and envisioned by a man Dexter Guilford, who I recruited to head it up. He looked at literature across this country, even across the world. And then we consulted with community activists and people most impacted by these cases. Said, here's what we think. Here's what we think will be the best way to handle these cases so that the most information can possibly be shared about them will be made available, and that's what we have done. We have a division now that has been recognized by both the NAACP and the Austin Police Association, which is no small achievement. In the area of drugs, I looked at our numbers running for office and found that the highest number of charges filed were possession of a controlled substance under a gram. The next highest involved family violence. So we decided that we would have to do something different in both of those areas. And one of the first things I did was to create a family violence unit. Now, going to the Commissioner's Court and asking for 10 new prosecutors is a non-starter in today's world. So we looked at the staffing of the courts as they stood then, and I decided that instead of 4 lawyers who were handling all cases in a trial court, we'd take one of those lawyers and devote that person to form a family violence unit. And we patterned the idea after the existing child protection unit, which has been a very successful endeavor in the DA's office and in this county. I also took 2 additional prosecutors, making a total of 10. These 2 intake prosecutors staff cases as they're coming in with the police and with the county attorney, so that we were able to charge the cases as much better on the front end. They weren't bouncing back and forth. We had a big backlog of cases that had been reduced or enhanced and were just kind of in limbo. We cleared that up. I'm proud of that unit, and I'm telling you, they've handled over 4,000 cases since I took office. It's a major problem in this community, and we're addressing it with the kind of resources I believe this community would expect us to staff. On the low-level drugs, I've read the literature across the country about the war on drugs and its disparate impact, particularly on African American males. And so I initiated, for starters, putting together a study by an expert to see if there is bias, or if there had been bias in our system and the disposition of these cases. We were able to put together some money with the help of the Commissioner's Court and funded the study, and it was conducted by Dr. Tony Fabello, who is a long time expert in criminal justice issues in Texas. And that study was very enlightening. It did say that there's a disparate number of African Americans being booked into our jail on those charges, but that he did not see race, gender, or age as a factor in how the cases were handled during the process. He did see, however, that there was one factor that made a difference into whether you had a dismissal, a finding of guilt, what the sentence was, whether you got diversion. And that factor was whether you had retained or appointed counsel. It was not a question we had actually asked, but it was an answer that provided the impetus that has led now to the creation of a public defender in Travis County, which is an idea I've supported ever since I was on the court 20 years ago. So we took that, and he suggested that to understand the disparate impact on African Americans, you really needed to look upstream at enforcement practices. So it launched a conversation with the Austin Police Department, and we are now looking at forming a diversion effort on those cases that would keep that person, in some instances, from being booked. And those conversations are proceeding. I'm getting the time's up signal. I have so much more to talk about. One area is we are looking at a new program to deal with mental health needs of people who are in the criminal justice system. And we are doing a whole community engagement effort that launched its first project today, which is an Expunction Expo. So I've got a proven record of reform in the 3 years I've been here, and I have got a vision for where we need to go, and I have the experience, the relationships, and the knowledge that it takes to actually execute that vision, and I am hopeful to be returned to office.
My name is Erin Martinson. I never planned to run for office, but I was approached by a group of advocates and survivors who I'd worked with locally and who were familiar with my reputation in the community. And when they asked me to consider running, I jumped on an opportunity to seek change on a broader scale. As the capital of Texas, Austin, I think the rest of the state looks to us to be a model community, but that's not what we have right now. Instead, we have a district attorney who's facing 2 lawsuits filed by victims of sexual assault for her failure to prosecute sexual assault cases and her mistreatment of victims. We have a district attorney who's walked away from a long-standing community collaboration, the Sexual Assault Response and Resources Team, and abandoned that working group that has been around and accomplished great things for many, many years. And we have a district attorney who, when she was appointed to the governor's sexual assault survivors task force, she was kicked off that task force before she could serve a day. I know that my experience working here in Travis County makes me the best candidate to make broad change in the district attorney's office. I've never been sued by the victims that I've worked with. I've been elected to and served in positions of leadership on multiple statewide and local task forces, and I've never been forced to resign or kicked off of those task forces. In fact, many of the survivors and advocates that I've worked with locally are supporting my campaign. I'm the only candidate in this race who's spent 20 years working specifically in our criminal and civil justice systems here in Travis County. I've worked in every office. I'm also the only candidate who's worked in every court that this office touches. I've worked in criminal court, I've worked in juvenile court, and I've also worked in child protective services court. I've worked as a prosecutor. I worked for 12 years at the Travis County Attorney's Office, where I led their protective order division to be a statewide model for protective order practice in Texas. And I spent a lot of time traveling all over the state, training other prosecutors to implement policies that would improve their divisions. But I also started my career as a criminal defense attorney. And I did that prior to becoming a prosecutor, which gives me a different insight into the needs of those who are accused of crimes in our system and the way that our system treats individuals accused of crimes. Because I've been on the front lines in Travis County, a front row seat in our justice system for 20 years. I also am the only one that knows what is and what is not working in our system. I've been frustrated by the fact that money and status buy justice. I've been frustrated that the diversion programs and the way that cases are being handled right now, we're not changing behavior. We're not intervening in a way that addresses the root cause of criminal behavior. And that's something that I'm interested in looking at. I know that I can make the change, the culture shift, not just for the district attorney's office, but for our entire community, for all of Travis County. And I know that I'm the best candidate who can walk in the door with the expertise that I've developed over 20 years without having to learn those things. You can learn the day-to-day operations of an office, but the empathy and compassion that I have learned and the expertise I've learned in working with both those accused of crimes and victims give me the best background and the best perspective to run this office.
Start with you and go the other direction this time. What are the main obstacles that stand in the way of prosecuting more sexual assault cases in Travis County? And specifically, what would you do to overcome those obstacles?
Sure. So the current obstacles, I think one major obstacle is that victims in Travis County don't trust our system. There's been a lot of coverage of the lawsuits that are pending against our district attorney. I think there's widespread knowledge of what's happening here. That has a chilling effect on victims coming forward and reporting their attacks. And not just for victims of sexual assault, but also victims of domestic violence, because the majority of sexual assault victims are sexual assaults are committed by intimate partners. So it's a chilling effect on the vast majority of victims of violent crime in our community. The obstacle that I see right now, and reading the pleadings in the lawsuit, it's clear these were very violent sexual assaults that were committed, and the explanations given for these cases not being prosecuted were unacceptable. So I think we need to start, one place we can start is by prosecutors meeting face-to-face with victims, regardless of which direction you're going in the case. Victims crave that, they need it. And if you can't take the case to prosecution, if you can't meet the elements of the crime, you can explain that to a victim in a compassionate way. I've had to do it thousands of times. And they walk away feeling heard. So because that's not happening right now, I actually created a program in Travis County to respond to the needs of victims when we started getting all these reports of the DA's office not prosecuting the cases. And what we did was we represented victims in that system. It's work that hasn't been done before. We represented them, we helped them officially assert their rights, and we demanded face-to-face meetings with the prosecutors. Some of those meetings were denied. So we think that's a starting point. A starting point is we will meet the victims where they are, we will hear their concerns, and we will address those concerns. I think we need much better training for our victim witness counselors who are working in the district attorney's office. Similar to when I was working at the county, a lot of the staff who are meeting with victims, who interact with victims on a daily basis, don't have any special training or experience working with specifically people in crisis or people who've experienced trauma. And it's a really specialized way of providing services. And so I think we need to make sure that either current staff is trained up or that we're hiring new staff that is able to address the needs of folks who've experienced trauma. I think our prosecutors need training. I think that, some of the finest prosecutors we had who have handled domestic violence cases and sexual assault cases in our community for a long, long time were terminated. They were not retained by our current district attorney. In fact, it was a group of prosecutors that our advocacy groups told our district attorney, these are the best. These are the best of the best handling these cases, and they were not retained. And so right off the bat, we saw that this was not a priority. And so really prioritizing the prosecution of violent crimes, of complex cases, making sure that these divisions have the resources necessary. I believe there are 2, maybe 3 prosecutors in that division right now. Not enough prosecutors to handle all the sexual assault reports that come in. I think that's a start. I think we need to rejoin the sexual assault response and resources team to send a message to our community that we're here, that we will stick through tough conversations, and we won't walk away when people are critical of our office, and really just start restoring that faith from the advocacy community and from survivors.
Eve?
Yes.
And your chance to respond to anything as well, too.
Thank you. Needless to say, I disagree with almost every single thing she said. It's not factual, and it's completely sending the wrong message. I am concerned because reports were down. I think it's because of the negative messaging that's been going on largely by my opponent and her friends, and it's not good for this community, and it certainly doesn't help victims. What we've done in the DA's office since I took over is more and better than was done for 2-3 years before I got there. And we have now an adult sexual assault unit that didn't exist before. Ms. Martinson likes to take credit for that, but in fact, what was the start of this was a grant that funded a counselor, a prosecutor, and a support person. the grant funding kicked in shortly before I took office to fund the support person and the counselor. The prosecutor was funded in May of my first year, 17. That grant was intended for only intimate partner cases, and I do disagree that the majority of these cases involve intimate partners. That's not exactly accurate. In fact, that grant was limited to 25 cases. So we looked at that and said, we need more than that. And I met with the sex crimes unit at APD and the people at TCSO, and we said, we can't give you a full-time prosecutor. We don't have the resources for that right now, but what we can do is establish regular hours that you will have a prosecutor out here. In fact, the intimate partner prosecutor and an additional prosecutor to work on cases with you, listen to what you've got, see what support you need from us, like help with a warrant or suggestions about what you might go look for. And that has worked very well. We decided to make that that person that was going out there on the staffings, and by the way, I staffed it with a very experienced lawyer from Harris County that I was able to lure away, and had tried many rape cases. So he and the intimate partner grant-funded position began that process. Now we decided, well, you know what? We really need to make that full-time adult sexual assault. So we took a position that the Commissioner's Court funded for us for 18 and stole it from what they funded it for and said, no, we're putting it on adult sexual assaults. And we told the commissioners what we were doing. We didn't just surreptitiously do it. We told Planning and Budget exactly what we were doing and why. So that made 2 full-time lawyers, and the grant position of the counselor ran out, so we asked the Commissioner's Court to pick up that funding, and they did. Then we came behind that the next year and said, please fund the position that we stole, because we still needed that work done, and you knew we needed that work done, but we need to keep doing this because it's working out well. And assigned them to not only staff with APD and then have it vertically prosecuted up through the trial courts, but actually stay with the case through at least grand jury presentation, and then as of October of 18, take it all the way through trial. So that has worked very well, and they do get training, and the counselors do get training. And all of our counselors are very well trained and very proud of the work they do with victims. Then we came back this year and said, we've got an opportunity to make this a very robust sexual assault unit by adding an investigator and an additional counselor. We got that. And then 2 weeks ago, the Commissioner's Court approved a grant application for us to add what we're calling a victim navigator. This is a person who will not just be there to counsel about getting through the criminal justice system and the trial process, but will assist these victims in getting additional services that they may need to support their staying in the system and helping prosecute the case. It may be help with a job or some other kind of benefits or transportation, childcare. What we have seen, and we have taken very deep dives into the data, and what we have seen is that the majority of these cases, in the majority of these complaints, the victim decides not to move forward at some stage of the process. And we want to see why and see if we can assist in that. I personally feel that this community can do a better job for victims because we have a great model here. We have our Child Protection Center. And out there we have a community response team that has CPS workers and social workers and prosecutors and police, and they sit around a table and they collaborate about what's going on. And they talk about cases and they talk about deficiencies in the resources. That to me is a great model. That Children's Protection Center also provides services to these children and their families. I think we need to move in that direction for adult victims. And I'm a proponent of doing that. When you ask what are obstacles to prosecution, well, the biggest obstacle that we face is the law itself. Many people have not read, most people have not read the Texas sexual assault statutes and do not understand what the state's burden is in proving a sexual assault. We have tried more cases to a jury in my 3 years than in the 3 years prior to me. And I go to these trials. I sit with victims in courtrooms. I go back and talk to the juries. I've been there holding a victim's hand when she's about to throw up, nervous and scared. And I have had to talk to a victim when a jury came back and found that person, the person she's accused of assaulting her, not guilty. All of these cases are heavily dependent upon what the evidence is and whether or not the state can meet its burden. Curing all of the ills in our society is really beyond the reach of a district attorney alone. Attitudes, mores, legal requirements, all of these are very complex, and they affect everything that's happening here. I am hopeful about the SART. I don't know why they started shooting at me before the ink had dried on my certificate. But they did, and the police department. And I understand pent-up frustration and anger, but I don't understand not reaching out and saying, can't we continue to work with the DA's office? You're the new DA. Can we talk about it? Instead of writing a letter saying, Brian Manley and Margaret Moore condone rape. That does not create a collaborative atmosphere. And it was a painful thing to have happen. And frankly, my people continued to go even in that kind of atmosphere. But in the meantime, it was important that we create a collaborative group to address these cases. And I reached out to Chief Carter at UTPD, to Chief Robledo at Pflugerville, Chief Radford at Lakeway. These are growing communities, and they have been trying to build up their ability to respond. And they all came to meet with us, and along with the sheriff and Chief Manley and the representatives of the SAFE Alliance who have Eloise House where the rape exams are done. And we did this big focus group process, and everyone in the room got excited. Yes, let's do this. Let's pull together and collaborate. And that group, the Interagency Sexual Assault Team, has been the actual collaboration that the national literature recommends communities form. And all of the people in that room are given rundowns of what happened in the latest trial. We discuss statistical issues and how to get the best statistics to show us what's going on. They discuss trainings, they conduct trainings. So while this negativity has been playing itself out, those of us who are charged with these responsibilities have continued to soldier on and do what I believe is an exemplary job, because I look at the national literature and I think if we had a report card that reflected all of these recommendations, we would score very, very well here. I am hopeful that when I win this race, that the SART will re-examine what kind of relationship it wants to have with law enforcement, because I am not the only person who is estranged from that group. We are not the only office that is estranged from that group. Collaboration is key to the solution addressing these problems. It is critical. And you can't have it when you're attacking people and calling them names in public. Thank you.
Mr. House.
Over the last 9 months or more, I have just been deeply honored and moved by the opportunity that I have had to sit down and talk with survivors, to talk with advocates for survivors, and to hear about experiences of trauma that you can't forget, and that that I know that I have never myself had to experience. The experiences of so many survivors are absolutely heartbreaking. And they are terrifying for all of us, for our communities, for those of us who have children, for those of us who have family and friends. And I just want to start by saying how grateful I am to survivors and advocates, whether they are the litigants in the lawsuit or the people who have been fighting this fight for decades here in Austin, for the courage and the bravery that they have shown in raising these issues and raising these concerns. I also have to say that, Margaret, I just think it is beyond the pale to even suggest that the reason that women, that survivors don't come forward, people who have suffered incredible trauma, that the reason that they don't come forward to report is because of survivors, because of advocates raising concerns about the system. I am sure that the criticism that the district attorney faced when she took office at the SART was painful, and I am sorry for that. I have no doubt about this. This business is rough, and I am sure it was painful. But in the role of leadership, in the role as a leader, this can never be about our pain. This can never be about how difficult this is for us, to hear criticism for us. The number one job of the district attorney is to keep our community safe and is to fight for the vulnerable. In this instance, who among us is more vulnerable than survivors of sexual assault? To suggest that it is survivors who need to grow up so that there can be collaboration, that is what leadership is. It is being able to hear the criticism, to work through it, and to get to collaboration. What I have felt and seen most starkly is that the injustice that women are experiencing here in Travis County, that the injustice that working people are experiencing here in Travis County, that the injustice that people of color are experiencing here in Travis County all flows from the same broken system. In 2018, if you want to talk about our report card here in Travis County, in 2018, the district attorney's office prosecuted approximately 40 cases of sexual assault. That same year, the district attorney's office prosecuted over 1,200 drug possession cases. That is the current state of the priorities of our district attorney's office. And those priorities do not reflect the priorities or values of our community here in Travis County. As I said, I have been so honored to be able to be a part of the discussions that survivors have been having over the last multiple months about how to address this crisis here in Travis County. And let me start by saying that throughout my career, if I have learned anything, what I have learned is that impacted people, no matter what the problem is, always know best what challenge they are facing and what solution they need in their lives to address that challenge. And I have been so honored to be a part of those conversations. And what those conversations center around is how we address harm in our community, how we address the culture of rape and misogyny that makes sexual assault, that gives people the impression that it is okay, that makes it difficult to talk about. And I on this point, I also have to disagree. The district attorney is the most powerful actor in our criminal justice system. It is absolutely the responsibility of the district attorney to try to shape mores and culture. If the law is broken, there should be no fiercer advocate at the legislature than our district attorney fighting to change those laws. But that is not what is happening. What it is time for in Travis County is a realignment of our priorities. It is time for culture change. It is time for a victim-centered, trauma-informed approach to sexual assault. And it is time to start packing all of these systems of oppression that make it difficult for women to come forward. The reality is that the majority of survivors of sexual assault are women of color. They are the same communities whose neighborhoods are over-policed. They are the same communities who disproportionately arrested for drug possession, who are disproportionately impacted by our criminal justice system. These things are connected. And if we cannot find justice for all of us, we can't find justice for any of us.
Would you like a minute to respond, and then we'll move on to another topic?
And I would request a minute to set the record straight on a few things as well.
Okay, but let's
I
do
think
this.
let's can
1 minute,
remove.
1 minute.
Okay.
You'd rather-
I will say this. It was not my pain that led to our ultimate withdrawal from attending the SART meetings. It was not my pain. It was the pain of the men and women in the DA's office and the Austin Police Department and the Travis County Sheriff's Office who were working these cases day in and day out, striving to do the very best job possible, who's found it impossible to stay in an environment where this kind of rhetoric was taking place. And so we all decided, we have work to do and we want to do that work. And yes, it would be great if we were all getting along, but we got to wait. Then the lawsuit came along, and frankly, everything that we would say was the SART meetings were openly soliciting plaintiffs to add to the lawsuit and giving out an 800 number for them to call. And my people came back and said, this is too much. And that happened to the sheriff's people, and that happened to the APD people. So I think it's a destructive thing, and I'm hopeful that it's going to work its way through, and then we will, at the end of the day, we will have built something stronger and better. But I know our ISAT is doing great work, and I'm very proud of it. And I know we are trying cases. I know we are serving victims. I know we are trauma-informed, victim-centered, and so are the police and the sheriff's office. And I know the dedication of the folks who are actually doing the work. And so that's my response.
Just real briefly, DA Moore says it's not her pain that resulted in leaving the SART, but she recently said in a forum that she now knows what it's like to be falsely accused, which suggests that this has been very personal for her. In fact, DA Moore walked away from the SART after the letter was written. And the letter was written because we had tried to have multiple conversations with law enforcement and our DA's office to no avail. There was no transparency. We were finding stuff out months after the fact, and we were demanding transparency and a seat at the DNA working group, a seat at that table. DA Moore also likes to talk about how many resources she's dedicated to the sexual assault unit, but I think it's really disingenuous to talk about that when all of this followed a lawsuit against her office for not prosecuting these cases. She says she doesn't know why victims fall off and we fall off a prosecution and don't want to cooperate anymore. But I know why, because I've been working with victims and I've been talking to them and listening to them for 20 years. And they fall off because the DA's office doesn't communicate with them, or the DA's office doesn't believe them, or the DA's office doesn't make it a priority, or the DA's office slams her fist down on the table in a meeting with a victim. They fall off all because of behaviors of the district attorney's office. And I know that because they call me and they tell me about it, because I've helped them try and navigate the system. And I still, to this day, get calls from victims. And as far as the law being an obstacle, I agree with Jose. The district attorney should be lobbying for changes to the law if we feel that it's not adequate to be able to prove these cases. In fact, our district attorney has not done any of that. And I've worked on the public policy committee for the Texas Association Against Sexual Assault, and we lobbied for changes to the law a couple of sessions ago, adding coercion to the statute to make these cases easier to prosecute. And so her lack of leadership really, you can't blame the statute when you're not providing any leadership around that issue.
Okay. Start with you on this one.
Sir?
Should all potential cases of police misconduct be reviewed by a grand jury?
Yes.
And if we could keep this one to 3 minutes, please.
Yeah, you bet. The district attorney's office works every single day with the police department. And it is incredibly natural that when you work with someone or with a group of people regularly, you begin to form a bias, one way or the other. I mean, it is just human nature. The reality is that, just 2 months ago, it was uncovered that there has existed racism at the highest levels of the Austin Police Department. And that fact confirms what working class people and people of color feel every single day in this community. And so it is incredibly important that the district attorney's office on this issue demonstrate leadership and ensure that bias will not infiltrate the process of determining when a police officer has engaged in misconduct. Because if that's not the case, people lose trust in this system. The process used to be that all police-involved shootings went before a grand jury. That is now a decision that the district attorney makes personally. And I don't think it is credible to suggest that when your job is to work with the police every single day, that it is credible that bias doesn't seep into that decision. But there's also more leadership that the district attorney's office should be demonstrating on this issue. When there are law enforcement officers who have engaged in misconduct and they continue to participate in our criminal justice system, they continue to serve as witnesses that lead to people's convictions and arrests, that erodes trust in our criminal justice system, and that makes us less safe. It is time for the district attorney's office to aggressively pursue all kinds of misconduct and be clear and transparent with the public and with defendants and their counsel when there is law enforcement who has engaged in misconduct, and to aggressively review cases where a conviction may have resulted from because of the testimony of a law enforcement officer whose bias tainted that process. So the short answer is absolutely yes. The district attorney's office should be speaking out against the racism that has been uncovered in the police department, and should be aggressively pursuing all kinds of misconduct to prevent that, to make sure that does not seep into our criminal justice process.
Me again, in the middle. We decided not to do that. We did to discontinue the practice of presenting every case. We did that very thoughtfully. One of the problems here is when he talks about bias. So what I did was I created a civil rights unit to handle officer-involved cases that would be independent in the office. The only person who oversees it is myself. We decided that we would impanel special grand juries to hear officer-involved cases. So they are given an orientation that fully educates them about the use of force, and they gives them all the time they need to hear all the witnesses in a case. Before, they were going to regular grand juries, and the presentations were sandwiched in between all different kinds of cases. Took a very long time. I got that suggestion from Ashton Cumberbatch, who's a former police monitor here, and I thought it was an excellent one. So we now have the special grand jury. Instead of presenting to a grand jury when we've decided to decline a case because it is legally insufficient, we issue a declination letter. These are available online on our website, and you can read them. And in those letters, we do a very exhaustive description of the evidence in the case and the law applicable to the case. I have been told by Reverend Joe Parker, who has had families who were impacted by an officer shooting, and Adam Lowy, who has represented families against the police department, that this is the most information that has ever been shared with the families and the community in their knowledge. We meet with the families that are impacted. Before we issue the letter, they are given an opportunity to view all of the evidence in our office. Some of them have even brought their civil lawyer with them. There is a victim witness counselor made available to them so that they are accorded all the chance to ask all the questions they want to ask and understand exactly what happened to their loved one. Finally, I formed a Civil Rights Advisory Council. Their membership of the group at this point in time is on our website as well. It's a very open group. We've invited people to join, and we've invited people who participate to bring others. It's a pretty broad cross-section of this community, and it includes everybody from Joe Parker, Chaz Moore, Arnold Garcia, some Dan Richard. I mean, it goes on, but they are thoughtful, experienced, deeply rooted in this community folks, and we present to them our decisions, and we also discuss with them things that we think are relevant to civil rights issues, including the handling of low-level drug cases, mental health issues, etc. What is the alternative to this? Presentation to a grand jury. What does that mean? It means that a state's attorney goes into a grand jury and tells them what the evidence is. Grand jurors are selected from the community just like pettit jurors. They're just like you. They don't conduct the investigation. They're at the mercy of those people who do conduct the investigation, right, to get the facts. So, and it's a black box because there's the laws pertaining to secrecy in the grand jury. We went a different direction. We went the direction of transparency, and it's providing this community with as much information as possible. We make decisions every day as state's lawyers about whether we have a sufficient legal case to present, and our dismissal rate right now is in the 40% range, made by lawyers who decide the case can't be prosecuted. We do that with these cases. And as I said earlier, what we have devised here is unique to this county, and I think it's meeting the needs of this county and the community that is most impacted by it. So that's my answer to using grand jury?
I absolutely think that cases of police misconduct should go before the grand jury. We should trust the grand jury process with cases of police misconduct, just like we trust the grand jury process with other crimes. And to do otherwise suggests favoritism and special treatment. We can prioritize the taking of these cases to grand juries. We can make body cam footage publicly available. And honestly, the research and the evidence behind this suggests that the least harmful and the most transparent way to deal with incidents of police misconduct is to take these cases, all of them, to the grand jury and let that system happen. And I agree we need to be doing other things in the interest of transparency with our community. The no-call list for officers who have shown bias, and especially in light of recent discoveries about racism and homophobia at the highest levels of our police department. This is information that needs to be shared. We need to ensure that the defense attorney and the person who's been accused of the crime have this information early. We are upfront about it. We have no-call lists. We're not going to use the testimony of individuals in our system who have practiced racist behaviors, especially with the most vulnerable in our community. And the community already has a hard time trusting the system. When you remove this decision about what to do with police misconduct, we're talking largely this affects communities of color and individuals suffering from mental health issues. When you remove this from that very public decision-making, the grand jury, it's suggesting that you are operating behind closed doors and you're not willing to be transparent with the community. And it just adds another level of mistrust in our system.
May I say one thing really quickly about that?
You could just keep it to a minute. We're
Yeah.
already in our time zone.
I want to say that we have a very robust disclosure system in our office. It's mirrored in the county attorney's office. Defense lawyers are provided disclosure files on any individual that if that information, it could conceivably in any way be useful to defense, whether it's actually Brady material or not, because of the Michael Morton Act, because of the State Bar ethics rules, we have a very, very comprehensive system and is automatically uploaded as discovery to the defense bar. And when we will no longer sponsor a witness because of some misconduct, we do inform the law enforcement agency of that. So now all of those systems are in place now.
So we are out of time. Anybody else have another question that they wanted to ask?
Very quickly, if
short.
you can, what's the best replacement for cash bail?
Well, there are a number of models that are in place all across the state and all across the country. And I'm pretty confident that there are enough smart people in Travis County that we can figure out which of those systems work best for us. So with respect to the district attorney's office, let me just say that the district attorney's office has an obligation to ensure that no one is sitting in our jail simply because they can't afford to get out. The district attorney's office should be carefully reviewing all of the cases where people are sitting in our jail pre-trial, and they should be asking the question, does this person pose a threat to our community? We currently use a risk assessment tool here in Travis County. That system is outdated and rife with bias. It does not seek to understand whether or not a person is capable of paying the bail that is set, and it penalizes people who struggle with substance use. That is not an assessment of whether or not a person poses a threat to our community. Instead, it should be replaced with a system and where the district attorney is carefully looking for incidents that are proximate in time, that are close to the incident that is the basis of the charge, that suggests there could be a threat to our community. And so what replaces cash bail is a simple system, a simple assessment of whether or not a person poses a threat to our community, and if they don't, they shouldn't be in jail. If we are worried about truancy, and we should be clear that truancy is completely different from a risk of flight. Truancy is missing your doctor's appointment, missing a court date. There are systems in place to help people remember that they have court dates, to call people, to send them text messages. There are systems in place in Harris County, in counties across the country and the state to help people get back to court. That is not the way our bail system should be used.
Okay, there's several things I can say about this. Under Texas law, you're entitled to the setting of a bail amount, okay? I brought a list of the people in jail because I think it's the best way for you to look and see who's in our jail, what they're charged with. We do look at this list. It is a list I look at. My managers look at. We look at who's been in jail, what are they in there for, and why hasn't this case moved. We do that on a regular basis. I am part of a committee, David Escamilla and I called together, and we are looking again at our personal bond practices because that's the alternative to the posting of cash, right? Is getting a personal bond. And we have about a 70% personal bond rate right now. And we're looking at, can we do that more efficiently? And one of the commitments we've made is to come out of this is to also look at, do we need to have bond hearings at 24/7? And if we do, then what's it going to take to staff those with defense and prosecutors? So a lot of work is going on. It's like I said, reform is an ongoing process, and that's taking place now. Right now, Mr. Garza is willing to take on a very onerous responsibility. It's really the responsibility of the courts. Judges believe they have the responsibility here to decide who gets released and who doesn't and what the bail amount is because that's their job. So it's important to work with the judges and to respect their role, and that's what we've been doing. It's having a very good collaborative examination of what's going on over there. So that, I think Travis County has been a long-standing user of the personal bond alternative to surety bonds, and we're constantly improving on that, and we'll be improving them as we continue down the path. So.
Erin, you get the last word.
Sure, thank you.
I'd like to respond just briefly if I can.
Well,
I can take 30 seconds.
you make charges, against her position or her policy. She responded, and I think that's fair. But if you want to take 30 seconds.
Great. I'll be very quick. The first thing I want to say is that, under the law, people are entitled to the setting of a bond they can afford, except for some very narrow circumstances. That's number one. Number two, we have a 70% PR bond rate. That's a solid C-. There are communities across the country who have PR bond rates in the 90s, and I would think that here in Travis County we would aspire at least to an A-, if not higher. The other thing I want to say quickly is, for so long, working people and people of color have been told that progress is a process, that we should wait. And I think the time for waiting for people who are sitting in jail, who can't afford to pay bail, who can't support their family, has come and gone. The final thing is, it is absolutely the job of the district attorney's office to take this responsibility. I mean, what we have heard time and time again is the idea that it's someone else's fault. Too many people are sitting in our jails because they can't afford to pay bail. That's the judges. There are racial outcomes in our criminal justice system. That's the police. It is the job of the district attorney's office to take that responsibility on.
I do not believe that money should be a determining factor of whether someone's released from jail. I think we can eliminate cash bail, and I think we have tools available to take into consideration the public and individual safety concerns. There are jurisdictions like St. Louis County and the District of Columbia that have entirely eliminated cash bail. And guess what? People are still going to court at the same rate they were before, and there's not been an increase in violent crimes. We can do this. I agree with Jose that the DA can provide leadership on this, and I am certain that the judges would follow suit if the DA's office said, we are operating under presumption that people get released from jail. I have no doubt about that. I also know, having worked in municipal court in Travis County, that there is no determination of a person's means at this point in time. They don't make that, they don't ask questions, they're not making any determination. They're basing it on what the crime is and their criminal history, which honestly doesn't have any indication about whether they're going to recidivate. The last thing that I would say is that we should provide 24-hour prosecutors to be making these recommendations, and defense counsel should also be present during this process. I had one more thought. I guess that's it.
All right. Thank you. Appreciate your time very much.
Thank you.
Thank you.
Thank you.